hereby open the meeting of the City Carrizo Springs Charter Commission meeting on Thursday, July the 7th at 6:03 here at the City Hall Municipal Building. I'm going to go to item 1, call the meeting to order. And we're going to go to item 2, roll call and establish a quorum.
Patty McDaniel.
David Briceño.
Roy Ortiz.
Elia Ramirez.
It is, the roll call is established and quorum, we did establish a quorum. We're going to go to item number 3, selection of commissioner officers. We're bringing this back up for the simple reason was that when we did the initial selection of commissioner officers, we had Sandra Little as chairperson, and then myself as vice, and you were secretary. But since Sandra Little became a councilman, she resigned, and they appointed Ms. McDaniel. And so, with that being said, we were wanting to go ahead and reestablish the selection of commissioner officers. So, open up the floor.
Do we have to reestablish everyone or just fill that position?
Well, then if we establish the president, you know, we're lacking a chair. Since I'm vice chair.
You were vice?
Yeah, I was vice chair.
Then I guess.
We were secretaries already, so that's what I'm saying, why are we redoing all of it? We're just missing.
Well, I would think my suggestion on nomination is nominate going to be Steph.
Oh, I don't have a problem with that.
Okay, and then we have to go through making the.
That was just my question. Do we have to reconstitute the board or just fill that position?
Well, we put this on the agenda because we had discussed it, or we tried to discuss it one time and it wasn't on the agenda, so we put it, we kind of put it off a little bit, and now it's on the agenda. We just need to establish Roy as the temporary, or as the permanent chair, because he's been acting as the temporary chair ever since Councilwoman Little became Councilwoman Little. So we just need a formal declaration that he becomes the permanent chair, and we don't have to select a vice chair if you don't want to.
I make the motion then that Roy move up and be the commission chair with no vice chair.
We have a first and a second done by Ms. McDaniel, Mr. Briceño, for Roy to become the chairperson. All in favor?
Okay.
Motion carries. Now, at this point in time, do we want to establish somebody as vice chair?
Well, my motion was without a vice chair.
Your motion was without.
But here is chair and he's as secretary. I think between 5 of us.
Okay.
So, quick question.
Okay.
Without the presence of board, for whatever reason, can we still do?
So somebody will just, for the purpose of that meeting, become the temporary chair.
Okay.
Or to just move to
That's what
the
we have a
next
quorum.
officer.
As long as you have a
So it'll be
quorum.
you.
Yeah.
Okay.
Yes.
So the motion was made without the vice. So I'm going to go ahead and go on, and that's officially been selected as the chair for the commission officers. We're going to go down to item number 4, discussion of appropriate action to review Articles 9 and 10. Okay. 9 and 10, the articles of the issuance and the sale of bonds. And number 10 is going to be the initiative and referendum and recall.
So, Chairman, if I may.
Sure.
So the Article 9 has, half dozen sections, and I was conferring with Mr. Maldonado about this, and state law, state and federal law are pretty prescriptive in what is and what isn't allowed in bonds, and we don't want to create more restrictions that are already there as far as bonds go. So the fewer provisions there are limiting the council and the citizens' options for bonds in the city charter, we believe is the better. So that was just sort of let's throw that to the wall, see if anybody had a reaction to it.
I read through this and that was my question, because in reading this, I mean, as long as we're in compliance with what the law is, that's what we should be doing, and that's none of this extra stuff.
Right, and so you're going to need to pass an ordinance anyway. I mean, there are sort of certain things that don't necessarily need to be in the charter, and that they're sort of best practice already or already mandated by state or federal law. So for the purpose of simplicity, for the purpose of giving the council flexibility, the legal recommendation would be to limit the scope of Article 9 as far as how prescriptive it is.
And that would be basically cleaning it up and everything being according to state law, in compliance with state law, right? Because of course this was written back in the 50s.
The bond market is a little different back then.
Yeah, that's right. So,
When's the last time that the city had a bond election? I can't remember.
bond election, not in 8 years that I was on council.
I can't think of any since I've been here since '99 that we've had one the way we have with the school. So that would eliminate pretty much the whole section to a couple of sentences that would say the city can have the power to borrow money in accordance to state law.
That's right, and you know, we've been talking a lot on the legal end about the best way of taking the charter to voters. Do we want to take them 100 different propositions with 100 different sections, or do you just want to take it article by article? I mean, I would recommend article by article because it's simpler for everybody. And the idea I had, I don't know if you would how you feel about this, is to shorten the bond section and put it under finance administration. So
That'd be appropriate.
condensing articles, making it simpler. So I think if that's what y'all want to do, we can.
More user-friendly.
Right.
That makes a lot of sense. Makes a lot of sense. So with that being said, that's what we're going to do, condense it and move it on into the finance sections, right? Make it more user-friendly.
Condense Article 9 and move it into a subsection of Article 7. Just so you know, of course I would run this all by you, but what I'm thinking right now is just the language of Section 89 being what we say with bonds, which is the city shall have the right to empower to borrow money on the credit of the city for any purpose consistent with state or federal law. Now, that's sort of how we would frame it.
Okay. Yeah, that pretty much moves it all the way to Article 10, which is initiative, referendum, and recall. Section 94, power to initiative, power to referendum. How do we want to take this one by one?
Is this article, as it is, in compliance with state law as well, or is there anything different that the law
And again,
either gives more time or less time?
I think that we would ensure consistency with state law. I'm pretty sure it is. The issue that I've seen on this is that the language, again, needs to be clearer than 1950s legal language. And that's the only suggestion I would have. We just should go through it and make sure that everyone's okay with the substance, I think.
That'd be the first section, correct? This is any initiative ordinance may be submitted to council by a petition signed by qualified voters of the city, equal in number to at least 25% of the number of votes cast in the last regular municipal election. Does that still hold true in the current law?
Yeah, so whichever, you can lower that percentage if you'd like.
Okay, but, what is, I guess, what is the norm that other communities have been using?
For a city the size of Carrizo Springs, I don't know what your municipal elections look like in terms of turnout, but 1/4 seems appropriate.
One time we had over 1,000 votes cast, and then the last one we had less than 400.
So, I mean, every time you'll have a different.
That was different number. Correct. So I would believe 25% would be a good number to stay at.
Okay.
Okay, the power of referendum, the qualified voters of the city shall have the power to approve or reject at the polls any ordinance passed by the council or submitted by council to a vote of qualified voters in which the subject to the initiative process under the charter, such power being known as referendum. Ordinances submitted to the council by initiative petition and passed by the council without change shall be subject to referendum in the same manner as other ordinances within 20 days after the enactment by council of any ordinance in which is subject to referendum. A petition signed by qualified voters of the city equal in the number of at least 25% of the number of votes cast in the last preceding regular municipal election may be filed by the city clerk requesting that any such ordinance be either repealed or submitted to vote by qualified voters. It's language that now 50 years from 50 years ago, has this pretty much cleaned up, or is it still?
I think we can make it simpler. The one issue I see, and this is not a legal issue, but a policy issue for you
Right.
to discuss, is this says that within 20 days the citizens would have to organize and get the petition signed. And I don't know if that seems like too long or not long enough, but
I think that's 20 days is really rather short.
On the,
If they wanted to petition on an ordinance,
model, it says 30 days,
30 days. That's more like
and on the signatures it says 10 to 20%.
Okay, so if we were going to modify the, is it 10 to 20%?
That's what it says for signatures.
But in section 94, the power of initiative, we kept it at 25%. So we're going to have to come into agreement, and we need to look throughout the rest of this. If there is another down the road, it gives a different percentage, but we'll get to that.
if you're gonna do 30 days but leave the 25% so that it stays consistent, it's not, it's not that we get just a huge amount of voters, so the difference between 20 and 25% of voters might be 10 people. If you're getting those extra 10 days, I think you can get that quota threshold.
So instead of striking the 20 days, we'd go to 30 days and keeping the 25%. Because like I said, we're gonna really have, as we continue to read this stuff, there is probably going to be another section where it calls for a percentage. So we're going to have to look at that, and we're going to have to see if it's going to be almost consistent.
so the policy you'd like to be uniform.
Right,
Yes.
that's basically what we're wanting to do. So it's okay, section 96, the form of petitions, committee of petitioners, initiative petition paper shall contain a full text of the proposed ordinance. The signatures of the initiative or referendum petition need not all be appended to one paper, but to each separate petition, there shall be an attached statement of a circular thereof as provided by each section, each signature of any petition paper shall sign his name in ink or indelible pencil, and shall indicate after his name is his place of residence by the street number or other description sufficient to identify the place. There shall appear on each petition the names and the addresses of 5 qualified voters who, as a committee of petitioners, shall be regarded as responsible for the circulation or filing of petition. Attached to each separate petition paper shall be an affidavit of circulation thereof that he and only he personally circulated the foregoing paper, that it bears a stated number of signatures, that all signatures appending thereto were made in his presence, and that he believes them to be genuine signatures of the persons whose names they're supported to be. Clean it up. Yeah, I mean, that would just, but see, like, sort of confusing. So, what does that have the model in there? The section in the model?
Does there have to be a limit? Because it says 5 qualified voters who is a committee of the petitioners.
So those are, so that's a kind of a provision that seems limiting. 5, a committee of 5, you can't pass around the petition to one person, that's a ticket to each person. Those are, and one of the things I've heard from this commission as we've gone through this is that you want more access for people, not less access for people.
Transparency.
Yeah, more transparency. Texas of 1950, late 1950s is different than Texas of now, so that's one of the things I'm hearing. So as we go through this, I'm just thinking about that, and these provisions that seem to make it harder to do seem inconsistent with that preference.
The model shows 5 as well.
5 as well.
Any 5 registered voters, they commence initially.
So those 5 people have to make the petition committee, and then they're the only 5 that can circulate the petition to get the signature.
Yes, they're the ones that can take the petition to you and have you sign it. They can't pass it around. Right. You're taking it to your family.
And then, like I said, they have to make sure that they are the people that are the genuine signatures and all that.
And the problem that I have with 5 is because if it's an issue that people feel strongly about, you're limiting the composition of that committee. Because if you have 10 active people that really are, want something done, why can't you have a committee of 10? Especially if you've had a heated election with a lot of voters, you're gonna need more in that committee to get the required signatures as well. I mean, you start playing with the number.
So I guess what I'm
As
hearing,
you said before, you don't want to limit the public. You want to, it's not a cover-up for anything.
so do we have to have
A number.
a number?
I don't believe that there's anything that would require you to do that. I think that the reason they want to have that number is so that you don't have sort of an LBJ ballot box situation.
Okay.
I think that's what that's designed to do, to ensure some sort of accountability. One of the things I'm noticing here is that each signer of any petition shall sign his name with his place of residence by street and number. Now we have voter ID numbers, so we don't need to put our, you have things that are, so you can identify yourself in multiple ways.
Validity.
To prove validity. So these are just things to think about, and I'd be happy to draft a couple options for the committee to consider at the next meeting in terms of how to approach this.
I believe on the form for the petition, at the top it says, I personally witnessed these 5 people sign the petition. So if that person is swearing, whoever it is, if there's any question, even if there's 10 people circulating the petition, each page that you get signed, you're having to swear to anyway.
And notarize it. I think it should have to be notarized.
So, I mean, does it matter how many people are circulating signatures they put on, that they gathered, they witnessed?
But isn't this saying that the only people that can circulate are the people that are on the committee? Right?
That's what I'm
That's
reading.
what that's saying.
So we can just remove that. We can say that, you know, the number of circulators is unlimited if you'd like to do that. I mean,
Well, I'm thinking of what you just said. I mean,
They could get out of
it
it?
could get out of hand. And
It's not gonna get out of hand if it's an issue that a lot of people strongly believe in, that it needs to be done. Because it's not that easy. It's not difficult to get signatures, but at the same time, it's not real easy. And if I'm going to circulate something, I'm gonna put my name on there. I mean, and I'm gonna be held accountable. I'm gonna make sure that it's done.
How many, on the last recall, it was attempted, how many people were circulating, do you know?
there's quite a few.
Well, they would have had to have gone by this.
Did I wonder they did?
I don't believe
I
so.
don't believe so, because there were more than 5 people
Was it?
circulating.
Oh, okay.
Yes. So, draft up something, let's see what the consensus
couple
is
of
going to be.
options.
Yeah, a couple of
Give
options
us-
that will be, you know, of course, we don't want to tie the hands of the citizens either. You know, we want to be able to give them that option. Again,
Flexibility.
flexibility to be able to show transparency.
So then, I mean, if we just raise it up to 10, I think after 10 people should be trained.
I think,
What do you think?
I mean,
Maybe just 10?
because if we're only getting, what, 25% of the vote, that's not that many votes to collect.
Well,
But if you do it by 10 people.
So what are our consensus here is basically 10?
Well, we've asked them to draft something, let's see
Yeah.
what.
Okay. Just let them draft something up and we come back and look at it.
we can look at other, you know, I usually what I do is I look at the model, I look at a city like San Antonio, I look at a couple other cities, you know, so what I'll do is on this particular issue, I'll look at like 10 of them and see what other cities in similar size are doing.
So we'll let you get something together and then we'll look at it and then come to a conclusion of how many we're going to have. And the filing and examination and certification of petitions, all petition papers comprising an initiative or referendum petition shall be assembled and filed with the city clerk as one instrument. Within 20 days after a petition is filed, the city clerk shall determine whether each paper of the petition has proper statement of the circular and whether the petition is signed by a sufficient number of qualified voters. The city clerk shall declare any petition paper entirely invalid which does not have the attached thereto an affidavit signed by the circulator thereof. If a petition paper is found to be signed by more persons than the number of signatures certified by the circulator, the last signatures in excess of the number certified shall be disregarded. If a petition paper is found to be signed by fewer persons than the number certified, the signature shall be accepted unless void on other grounds. After completing this examination of the petition, the city clerk shall certify the results thereof to the council and its next regular meeting. If he shall certify the petition is insufficient, he shall set forth in a certification to the particulars in which it is defective and shall at once notify the committee of the petitioners of his finding.
Is it addressed in here, who will determine how many signatures they need to get?
I think it goes, that's city clerk, right?
Yeah, so it will be 1/4 of the last regular election.
Okay, but will the city clerk give the petitioning committee that number so they know? That way
Okay,
they're not
that's-
having to guess.
I guess that would be something that we'd have to put in language that once a petition is ready to be filed, or they're coming to ask to file one, that the city clerk, give them a number, okay, 25% of the last regular election, and that's what the amount, okay, if it was 300,
Yeah.
25% of 300.
And that way they know how many they need to get and not come back and say, well, we've got 300, oh, well, I miscalculated, or that's not the right number, or you need this many more. Just so that that it's done in good faith, that
Sure.
they're bringing the number that's required, and you're not trying to get them confused from the get-go what they're supposed to do.
I see.
And so there's no, I'll think of the word. But just so there's no playing around with the numbers at the beginning, and then I got you at the end that you didn't come up with enough.
Right. Trying to think about how we would do that. Because when would the city clerk have to say that?
Well, I would,
Since
Well,
the initial-
yeah.
I would expect if I'm gonna file a petition, or try to get a petition going and all that, I mean, I'd sure like to know, hey, you have to get 75 signatures. Okay, so we go out there, committee, we have to get 75 signatures. There's 3 of us, 4 of us, 5 of us, whatever. Okay, so we get the correct amount of signatures, or maybe a little more, just to be on the
Right.
safe side.
Right.
So,
But when you come in and say you want to file a petition, and they give you the papers, because they give you the papers that you have to get filled out, they need to be able to either give you enough copies for the amount of signatures you need to turn back in, or tell you, look, here's a master copy, and make all the copies you need to bring back 300 signatures.
So somewhere in
At the
section
beginning.
94, 95, the city clerk shall notify petitioners of the minimum required.
Number
the
of
minimum
votes.
required,
Number of signatures, of
Numbers.
qualified signatures.
qualified signature, that way of the last regular elections can't be
And-
special.
Yeah, and at the end of your 30 days, hey, I only got 200 and I needed 300, I'm not gonna make it in time.
Right.
What about that statement where it says if the petition papers have to be signed, it's about halfway, by more persons than the number of signatures certified by the circulator? The last signatures in excess of the number certified shall be disregarded. I have a problem with that statement.
Well, I would think that, because the city clerk is going to have to certify that my signature, that I'm a actual voter in the city of Carrizo Springs. And so my signature is certified because we're all voters inside the Carrizo. And say, for instance, all 3 of you are certified, you live in the city, and I'm living outside the city, well then, my name will,
But I think of that one, it says like if there's
It's complete.
25 slots to sign,
And
and
there's
then you
more.
put 26, 27, 28, and those will not count. Is that what it means?
I don't know, because I interpret that if you need 250 signatures, and there's 10 on the committee, so everybody needs to get 25, but if I get 30 signatures, they're gonna strike my 5 off of
I
there.
don't think I see it that, I think I see it as.
How do you see that?
The way I see that is you have a piece of paper, and the circulator would have to say, this piece of paper has 8 certified signatures. The circulator would have to certify it, that it has 8 signatures. If there are actually,
No.
if there are actually 10, the 2 that aren't certified by the circulator would be voided.
Just like you, I was thinking that if there's 250 that we need to get and we get 300, the 50 will be disregarded.
Well, it won't matter, you got your 250, boom, we move on to we
A
move
petition
on it.
paper, I think, is one piece of paper that has signatures. And when a circulator brings it into the city clerk, that circulator has to say, this petition paper has 10, this has 12, this has 8. So if the circulator says this has 8 and it actually has 10, the 2 extra wouldn't count.
Okay, I see what you're saying. Is that when the circulator goes out and says, I certify that there is 8, but there's 10 and there's a notarized, their notary says, he signs it, it says, I certified that he said there was 8 and there was actually 10, so the 2, is that more or less what we're talking about?
Right.
Yeah, I think so, yeah.
Because they don't want is for a circulator to notarize 8 and then add a bunch more on there that aren't notarized, they get counted.
No, I understand. I understand that part. But, you know, the way I was looking at it is that, okay, we needed 250, we got 300. I mean, you always want to play on the safe side because, I mean, let's just say 10.
These are the ones they're gonna throw out.
Right.
They
the ones
said,
that they're not certified because they're not registered voters within the city.
They're not sworn to.
Right.
Yeah.
Any more of it?
So once that language is simplified, it'll make more sense.
A lot of the language is going to be simplified in some of this, right?
And is it always limited to one person, the city clerk? Because I know the last time that a petition was circulated here, there was an issue with that. Is it only that one person, or can there be someone else in addition to the city clerk?
I think the city clerk, and we can clarify this is a good thing to clarify. The city clerk is the official whose job it is to sign off on all this stuff. Now, the city clerk can ask other people at City Hall to help sort through it all, but the city clerk is the person who has the legal authority to sign off on this stuff.
How would I feel comfortable if I've circulated a petition? How could I be assured that what's going to be done is going to be done in good faith? Because I think the last time there was a lot of issues.
I've seen this.
Can we come back and say, okay, which ones did you deny or disqualify? Can we come back and ask for that? Or can the people come back?
Well, I think it says it in there that everything that he or she did away with, they've got to be able to say to the council, okay, this is why it failed, because they were required to submit 250. After submitting the 250, it came back that only 230 were actually certifiable registered voters within the city, and this is why the petition failed.
No, but can they come back and say, okay, this one specific name was not counted because
They don't
this.
want-
This is
That
an
way you
Indian
can go
signature.
and find, that way if they erroneously disqualify somebody, you can say, no, they are. That way you can argue it back.
Correct.
It doesn't give you a chance for rebuttal.
Well, no.
Well, so it says at the end of this, section 97, the city clerk shall certify that the petition is insufficient, set forth the particulars in which it is defective, and notify the circulators. In section 98, the petitioners may amend at any time within 10 days after a notification of insufficiency, so that they can come back if it's not insufficient.
Okay, but in section 98, is there language enough in there, like what David was saying, is that, just tell me exactly.
Yeah, this
Right.
seems final. It doesn't matter that I'm not in agreement with what the city clerk is saying. Because once the city clerk, states why it was defective and notifies the committee of his finding, that's it.
So we want, in the model charter, if the petition has been certified insufficient and the petitioner committee may file a request that be reviewed by council. So I guess the concern would be there's sort of a conspiracy at City Hall to prevent this from happening, which people believe, I've seen it actually, and so that's what you're trying to
avoid.
Right.
Transparency is what
Right.
they're looking at.
What's the safeguard in place to ensure that everybody can have faith that everybody's playing by the rules? Right.
Well, I think that section 98 gives you that chance to come back, so that if they wait till the 30th day, you bring it 5 o'clock on the 30th day, they look and say tomorrow, well, you didn't have enough signatures, and that's the end of it. They have to show you which signatures weren't valid, so that you can, either, I guess,
Yeah,
you can
contest the orders.
argue, contest that they are valid. But if you fall short on your 30 days, you don't get an amendment to come back and get an extra 10 days, right?
Yeah,
See, I don't think this was
Read,
done.
go ahead and read section 98, all of it.
An initiative or referendum petition may be amended at any time within 10 days after the notification of insufficiency has been sent by the city clerk by filing a supplementary petition upon additional paper signed and filed as provided in case of an original petition. The city clerk shall, within 5 days after such amendment is filed, make examination of the amended petition. And if the petition still be insufficient, he shall file a certificate to that effect in his office and notify the committee of the petitioners of his findings, and no further action shall be had on such insufficient petition. The finding of the insufficiency of a petition shall not prejudice the filing of a new petition for the same purpose.
See, I don't think this was done. I don't think this was done the last time.
And probably, I mean, because it's still, I guess the way you read it, the way I heard you read it is that there is room for.
There is an opportunity.
There's still an opportunity to amend and correct everything, you know, and it gives you the amount of days to do it.
To correct, but if you were short in the first place, you don't get an if you knew you needed to come up with 300 and you only came up with 250, then she's gonna file a certificate that says it was insufficient for lack of signatures. Do you get an additional 10 days to come up with those 50 signatures, or do
Well, you
you?
should.
It doesn't say, it just says insufficiency.
yeah, so I think insufficiency is broad. So if it's lack of signatures, if some of the signatures aren't proper, whatever. So the way I read this is, you get one shot at it, the city clerk can say yes or no. The city clerk says no, you have 10 days to take another shot at it. I think the issue is if the city clerk's just going to say no, 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 the city council tells the city clerk to do that, for example. Well, is there a way to bridge the gap? So the model charter says court review, but I don't know that we, I don't know how we want to do that.
That would be difficult, because that requires money to file a lawsuit to go that route, and that's
And the lawsuit's not gonna, it's not like it's gonna happen the very next day. I think it's gonna take.
What about the court clerk to be certified by the city attorney?
Main city attorney / municipal judge. In this case, we have an attorney, we have an attorney, the attorney of record, and then we also have the municipal judge.
You want to take it out of the city clerk's hand?
No. What I think we're just saying is that, I think the question was just leaving it to one individual, right? No oversight, I guess is what I'm hearing.
To assure that, you know, this one person has the one and only say-so about this petition. You know, in other words, you and I may disagree on a signature, and I might say, no, that is the signature, that matches, and you say, no, it doesn't. It doesn't. Because if you only have one person, she says it doesn't match, it doesn't match.
Oh, so you want to bring somebody in to then be an arbiter between the petitioner and the city?
Somebody else, and not necessarily, I don't see how it could be taken out of the city, but looking at the composition right now, because most of the time, who appoints a city attorney? It's not your council, and they're going to appoint whomever they want in there. I think we can safely say that the municipal judge wasn't necessarily claimed by the last councils. So he would have been an independent person if he was included. I'm not saying who should be on it, I just think it should be someone else in addition to, but somebody that we can have, that the people can have faith.
Because the city clerk, she certifies, he or she, after the election certifies that everything went okay, sends everything up to the, with the office of the state,
Secretary of State's office?
Secretary of State's office certifying that the election that happened here in Carrizo Springs was true and correct. So,
I would want the process to stay with the city.
yeah, I
clerk.
agree with you with that. And I guess what Ms. Ramirez is saying is that.
In addition.
In addition to,
But then
because.
that gives them the opportunity to say, I'm not here today, or I'm on. I mean, you know what, then I see it as being volleyed back and forth. I'd rather one person, it's your job and you need to be there to do it. Because then, well, if you have a complaint that they're not doing their job, that's a pretty big,
But when you leave it in control with one person, then what assurance does the public have? I mean, was this the amendment of petitions? Was this made available to the last? I don't think so. Did they have an opportunity to come back and get the additional? I think they were told they just didn't have enough signatures. They threw out I don't know how many.
yeah. Oh, I think they said, well, they couldn't find the rest of them. So they got lost.
But then
That's the point.
The days was not afforded, I guess is what you're telling me. But I'm hearing from you.
The 10
According to,
days.
the 10 days were not afforded to be able to correct the insufficiency.
No, they were not. And, but I don't think they pursued it either.
Right, and well, because I guess they really didn't read into into what the city charter was, and of course, at that point in time, whichever the city clerk was, maybe was not knowledgeable.
Right. Because it's not something that happens all the
Yeah,
time.
so there could have been fault at both ends.
Well, let's say the city clerk is, for whatever reason, is not available. If they're gone for
Well,
medical or
5
something,
days.
you know, then who does it?
See, safety net, that's what I'm hearing also. Because like I said, it's a heated situation where the city clerk
Or they don't make
Finds-
themselves available to receive.
finds himself one way or another, you know, and you know what, this is gonna happen. I put in my vacation the day after I was received, and they're supposed to 5 days. And does 5 days mean 5 working days or 5 days?
Have you seen it that it's always limited just to the city clerk?
Yeah, I mean, that's usually the city clerk's function. We could say, because it's hard, the model charter does say, final determination as to sufficiency of petition shall be subject to court review. Court review could be the municipal judge. So, at the end of section 98, the city clerk shall within 5 days make an examination of the amended petition, and if still insufficient, shall file his or her certificate to that effect in office and notify the committee. At which point the committee can submit to the municipal court judge for final determination on sufficiency.
I think though that this section's trying to eliminate it escalating and just saying, you know what, at that point, just start again. Because it doesn't prejudice the filing of a new petition for the same
No.
purpose.
Okay, I'm short, going through the 5 days, still short, you know what, I'll file it all over again.
Yeah. That way it keeps the fight, but it keeps it between the petitioner and the city clerk, so that you're not getting more and more people involved, and then it makes it more complicated.
So if the first petition fails, lack of signatures, there's no time limit to wait in between. You can just start the next
right
day
again.
and continue.
But now you know who else would be willing to sign again. You go back to them and get them to sign again, and
I mean, this section is very important, because I think
Mm.
because we've seen.
So, we've heard just the model, the language on the model charter.
Yes.
Which one are we going to be more comfortable with? And which do you think the public is going to be more comfortable with?
It is. pages. It's 6.04 D on the model signature.
So in the model, it would come up to the city council to review. And if it's to remove a council member, they don't get to weigh in. Or it can go to a court review. And still, if they keep striking it down, you just start again. If they find it's just insufficient.
And there's no limit to the amount of times that you could refile that same petition.
I've once seen in sort of in practical application, I once saw petitions be found insufficient, but they were so close where the council said, okay, let's just consider it anyway. You know, there is enough pressure in that situation.
Because a petition, if you get enough signatures, it doesn't mean that the council has to now do what you petitioned for. It just means that now they have to call an election to decide if the voters want to. So you still have that additional step you need to move to.
But as you can see in the language, it just states the last resort is court. Court order, not by court order, but by the review by court.
Final determination as to the sufficiency of petition shall be subject to court review. Court.
Which court?
See, most all of it is still going through the city clerk.
Is it hot in here? It's me. I'm usually cold.
So, good or
Yeah,
sure?
I've been all day.
So, what do we want to? How do we want to?
Did you get the memo I sent y'all, or that somebody from our office sent you? No?
Yeah, that is from last week.
Yeah. It was last week we were supposed to meet. It wasn't posted. So I should have done this at the beginning of the meeting. I had drafted up a summary of all the things we talked about. And the reason I bring this up now is because I thought that on this question, you know, on this article, it looks like we're going to be reviewing options as a commission again in the not too distant future. So what we could do is I could write up something for this section 98. Basically, we've already talked about how we want some options on some of this, so I could just write something up and then we could go from there with new, fresh language.
I think if it could be simplified, that might help us make an easier determination of if it's going along with our ideas. I think my main concern is making sure that the clerk tells the petitioner how many signatures are needed. And then the rest of it, I kind of feel like I'm okay.
Let's see what we can draft up for the section 98. Being that we want to make sure that easily, that can be read correct or easily, and the transparency is there, that would, user friendly is what we want to do, because most of the language back in the 50s were kind of.
Yeah, I think as long as we know what number we need
Mhm.
and that we know why something was rejected,
Mhm.
And have time to fix it.
then
Right.
we have to fix it.
And then that's fine. And if it's still insufficient,
That they be given due process,
Right.
that it
It
has
be
to
due
cost for
process.
everything.
and once it's insufficient, you know what, we can start again.
Then we have that in place, then I don't think it should matter who the person
Well,
accepting or denying.
we've got to be able to make sure that we have the trust, and because actually the city clerk is appointed. Okay, obviously the city clerk is appointed because they have they have confidence in it.
That's best practice.
Best practices, that's the way it should be. But when in the heat of the moment, one way or another, people are going to right away say, well, the city clerk did it this way because of, they're going to start speculating why it did not pass or not. So, and that puts a lot of pressure on the city clerk, because he or she does have to do this.
And that the city clerk is strong enough to stand up to, whether it's the mayor or the city manager, say, this is what the law says, and this is what has to be done. Because if they're going to be redirected, regardless whether it's right or wrong, it doesn't do us any good to have it in writing.
Sure. Due process. Okay, so we're gonna, we know what more or less what we want in the language for 98, section 98. It's going to section 99, called effect of certifications and referendum petitions. When a referendum petition or amended petition, as defined in section 98 of this charter, has been certified as sufficient by the city clerk, the ordinance specified in the petition shall not go into effect, or further action thereof shall be suspended if it shall have gone into effect, until and unless approved by the qualified voters as hereinafter provided.
Which is what you said, that's the next.
That would be the next step. And just clean up the language on that.
Right.
And for section 100 of this one, and it says consideration by council. Whenever the council receives a certified initiative or referendum petition from the city clerk, it shall proceed at once to consider such petition. A proposed initiative ordinance shall be read, and provision shall be made for the public hearing upon proposed ordinance. The council shall take final action on the ordinance not later than 60 days after the date on which such ordinance was submitted by council by the city clerk. A referred ordinance shall be reconsidered by the council, and its final vote upon such reconsideration shall be upon the question, shall the ordinance specified in the referendum petition be repealed? So it's, then we're good with that. It's 60 days after everything is said and done.
And this is in relation to an ordinance that has been
Ordinance,
passed.
yeah.
This is not for a recall.
No.
Recall is addressed.
It's
addressed.
Is later in the.
Right.
yeah.
This is an ordinance that the council has passed. And I don't remember if that's ever happened before.
An example would be like that you're allowed to keep livestock that's for stock show purposes within the city limits. And you have neighbors that don't want that or are opposed to the smell or whatever, and they want to initiate it.
And that one would be also something that we would just need to clean up the language on it. So submission, and we're going to section 101, submission to the qualified voters. If the council shall fail to pass an ordinance proposed by the initiative petition, or shall pass it in a form of a different form that's set forth in the petition therefore, or if the council fails to repeal a referred ordinance, the purpose or referred ordinance shall be submitted to qualified voters not less than 30 days nor more than 60 days from the date the council takes its final vote thereon. The council may, in its discretion, and if no regular election is to be held within such period, shall provide for a special election. Questions on that? Any comments? Just clean up the language, if needed. Just a question. If, let's just say, for instance, the council sees that there is a petition out there to repeal a certain ordinance, referendum and all that, does the council have to wait for all the petitions and all this to come by, or can they just say, you know what, maybe we
They don't have to wait, yeah.
Yeah, maybe we
Right.
reconsider, maybe we didn't think this one clearly enough, bring it back to the table.
Oh, yeah, because at any time they can
Yeah.
change their mind and just make a new motion to repeal it or change it so that it makes the people who are petitioning not necessarily happy, but if they take their new ideas into consideration, say maybe we need to just change our language a little or adjust it to include so-and-so for the case.
Section 102, the form of ballot for the initiated or referred ordinances. Ordinance shall submitted to the vote for the qualified voters in accordance with the initiative and referendum provisions of this charter shall be submitted by ballot title, which shall be prepared in all cases by the city attorney. The ballot title may be different from the legal title of any such initiated or referred ordinance, and shall be a clear, concise statement without argument or prejudice, descriptive or of the substance of such ordinance. If a paper ballot shall have below the ballot title and the following propositions, one above the other, in the order indicated for the ordinance and against the ordinance. Any number of ordinances may be voted on at the same election and may be submitted on the same ballot, but any paper ballot used voting thereon shall be for the purpose only. If voting machines are used, the ballot title of any ordinance shall have below it the same two propositions, one above the other, or one preceding the other in the order indicated, and the qualified voter shall be given the opportunity to vote for either of the two propositions, thereby the vote for or against the ordinance. Clearing it up. I guess a lot of this is we're pretty much agreeing on, but it's just making simplifying it. The results of the election, if the majority of the qualified voters voting on the proposed initiative ordinance shall vote in the favor thereof, it shall thereupon be an ordinance of the city. A referred ordinance which is not approved by the majority of the qualified voters voting thereon shall thereupon be deemed repealed. If conflicting ordinances are approved by the qualified voters of the same election, the one receiving the greatest number of the affirmative votes shall prevail to the extent of such conflict. And then now we're talking about, we go to section 104, it's calling the repealing ordinance of application. The initiative of the referendum ordinance adopted or approved by the majority of the qualified voters shall be published as provided elsewhere in this charter and may be amended or repealed by council as in the case of other ordinances. Questions on that?
It's treated like every other ordinance, right?
Exactly. Now we're getting.
So the voters can pass an ordinance, and at the next meeting, the council can repeal it.
Yes. It's crazy, right?
They'll love democracy.
I mean, it would really have to be just something outrageous for that to happen, because those people would have to know they will never get elected again if they do that.
But again, you know, and sometimes we need to realize that we need to do what the public wants us to do, not to fear, well, I'm going to be unpopular, I'm not going to get elected. That should never be anything we need to think about before we're actually working on this kind of stuff.
Yeah, but if you're not serving the people's wishes, then obviously.
Yeah.
I mean, it could be, let's say it's a group of young, they just rather to roll for the first time, but right, and they want something crazy passed, and so they get all their friends and
Like the music, because there's an
Right.
ordinance in reference to the music.
and it passes because all their friends came out and voted and whatever. You know, something like that, I guess. I mean,
Yeah, that's
then the council comes like, nope, sorry.
the reason for it.
Okay, now we're going to get into the part that we were trying to refer to earlier, and then that is the Section 105 recall general. The mayor or any members of the city council may be removed from office by recall. In Section 106, the recall procedure. Any qualified voter of the city may make and file with the city clerk an affidavit containing the name or names of the officer or officers whose removal is sought in a statement on the grounds for removal. The city clerk shall thereupon deliver to the qualified voter making such affidavit copies of petition blanks demanding such removal. The city clerk shall keep a sufficient number of such printed petition blanks on hand for distribution. Such blanks, when issued by the city clerk, shall bear the signature of the officer and be addressed to the city council, and shall be numbered, dated, and indicated the name of the person of whom it is issued. The petition blanks, when issued, shall also indicate the number of such blanks issued and the name of the officer whose removal is sought. The city clerk shall enter into a record to be kept in his office the name of the qualified voter whom
Checking my sources.
I'm checking any sources. The city clerk shall enter into a record to be kept in his office and the name of the qualified voters from whom the petition blank were issued and the number issued to that said person. I think that's something we were referring to the referendum petition. See, this doesn't specify, this part right here doesn't specify there needs to be a certain amount of number, but there's pages, and the city clerk needs to make sure all the pages are numbered. So in this year, if I'm reading it correctly, it doesn't have to be a committee of 5 or 10, does it?
It's one person
It
who's
is.
given however many pieces of paper they need, no more, no less, and this one person is sort of in charge of circulating. They make it harder to recall than they do to initiate.
Yeah, so if they issue you 20 pages and they number those 20 pages, you have to bring back exactly
20
those.
pages.
So the question is should that be the case? Or should it look more like an initiative?
Well, because then, I think for simplification, it should look like the initiative.
So we have two different processes for an
Right.
initiative and a
Mhm.
recall. And, the recall is way harder on people. So
Does the state law outline how?
you have broad powers on this
Yeah.
record. So,
That would be the same thing. I mean, it should be the same for whatever.
Same format,
It's the same format.
referendum and petition.
so same format for procedure.
What do you think?
Except for the part when you get to that the city council then doesn't have the power to recall that person, they have to call an election.
Right.
Once you've met your requirements, that you've gotten your signatures, they need to call a
So
special
that,
election.
and they address that in
Let's
107
go back
108,
to
so we'll see
106,
what
I'm sure.
we'll see what it says. I mean, we'll see if we like it.
And then we still have some questions gonna work on section 106, the procedure.
Right, so rather than it be one person who gets 20 pages, which then in effect, the city clerk is telling you you need 20 pages worth. They can't come back and say, oh, you needed 24, but you only gave me 20. So,
On section 107, the recall petitions to be effective must be returned and filed with the city clerk within 30 days after filing of the affidavit required in section 106. And it must be signed by the qualified voters of the city equal to the number to at least 51% of the total number of votes cast in the last regular municipal election at which the councilmen were elected, provided, however, that the petition shall contain the signatures of at least 300 qualified voters of the city and shall conform to the applicable provisions of section 96. No petition paper shall be accepted as part of the petition unless it bears the signature of the city clerk as required in section 106 therein.
So what they're saying is 51%, and if 51% is 200, you still need another 100.
right.
Right.
300 minimum.
Yeah, that's a little.
That's a lot.
Yeah, they're making it really hard to recall somebody. I don't know if that's good or bad. I'm just saying it's way harder than it is for an ordinance.
But
I don't
then,
think you want it to be as easy as repealing an ordinance.
but then why
When
would
we get the election,
then-
the last election. That was what, 400 minutes?
But the election prior to that was what?
1,000,
Thousand.
yeah.
So, but then again, it says, in the last regular municipal election in which the councilmen were elected. So,
So if he was elected in one that there was a lower turnout, that's the threshold. But if he was elected at one that there was a high turnout, that's the
Okay,
threshold.
is this talking about the last election, or is it talking about if you're wanting to recall me, how many votes were cast when I ran for office?
It says the
That's-
last regular municipal election at which councilmen were elected. So it could
Oh,
be.
not necessarily
Yeah,
that
that one.
council.
Right.
Okay.
Right.
Okay.
So, yeah, it's my issue with this, just being a lawyer, is that it's so different than, and when you look at the model, they have similar processes. So it's still harder to recall somebody in the model than it is to initiate an initiative, but it's not such a vastly different process. So I guess what I'm asking is, when we're looking at options, do you want the processes to be similar, maybe with a different threshold, or do we want sort of different process?
I think similar, but with a little bit higher threshold.
so you're saying do away with 51%
No,
or make it
that-
higher?
The 51% threshold.
But eliminate the 300?
Well, in this, the different process is what I'm referring to is on the other one, you saw you had the circulators and you have these affidavits and stuff, and on this one you have one person that comes in, and they're given 15 sheets of paper, and they have to have these 15 sheets of paper, so it's just way different of a process. So,
But it doesn't mean that once that person leaves here, I come in and I file, but once I leave here and I'll ask Roy to help me and I'll ask you to help me and I'll give you 2 pages or whatever, doesn't mean I can't do that.
that's true.
It doesn't say anywhere, it just says the one petitioner, hey, this is the 20 sheets I gave you, you have to give them back, but it
I
doesn't
just
say.
make sure that I get those
Yeah,
numbers.
to certify or
Yeah,
whatever.
it
That
doesn't
always
make,
says.
doesn't mean that, okay, I filed the initial, but I got you guys, I'm gonna give you 20 sheets. So,
I'm kind of okay with the 300.
You're okay
but
with
still
300?
needing to meet. I mean, because I don't want it to be a witch hunt on somebody.
Not that
If you want to
easy.
remove.
Yeah, that's what you're saying.
Not too easy. Yeah.
well, then just leave the 51% of them and the
51 and the 300.
300.
I'm good with that, as long as the process is easy, like it is for the referendum, for the ordinance.
So it's a higher threshold but an easier process.
Right. Okay. Okay, section 108, recall election. The city clerk shall at once examine the recall petition, and if he finds it insufficient in the compliance with the provisions of the article of his charter, he shall, within 5 days, submit it to city council for his certification to the effect and notify the officer of sought to be recalled in such action. If the officer whose removal is sought does not resign within 5 days after such notice, the city council shall thereupon order and fix a date for holding a recall election. Any such election shall be held not less than 30 or no more than 60 days after the petition has been presented to the city council, and at the same time as any municipal election held within such period. But if no municipal election shall be held within such period, the city council shall call a special election to be held within the specified period. Does that still hold true? Because now there's either an election in November,
It's a uniform election.
a uniform election. So will the language go to, instead of saying it in 60 days and this, that, and the other?
Would be
go
the
to-
next practicable
Or uniform.
election date. Because if it's all certified 3 days before election day, you can't make that happen. So
Exactly.
just the next practicable uniform election date, I think is the way it should be.
I think that's what happened in our neighboring community, is that there was no, they were saying that by law, I think they'd say the next uniform, November had already passed, the next uniform coming up was May.
And they were already gonna be out anyway.
Yeah, but that's what law states now, right?
Right, you have to have your election in May or November.
So that language in there will be fixed,
Yes.
I mean, will be corrected into to specify the next election. Okay, section 109, ballots in the recall election. Ballots used at the recall election shall conform to the following requirement. 1, with respect to each person whose removal is sought, the question to be submitted shall the name of the person be removed from office of the name of office by recall. Number 2, immediately below each question there shall be printed the 2 following proposition, one above each other in the order indicated. For the recall, the name of the person, or against the recall for the name of that person. Pretty much like the petition and
Right.
referendum, right? Okay. All right, and we go to section, no questions on 109? 109? Section 110, results of recall election. If a majority of the votes cast at the recall election shall be against the recall of the officer named on the ballot, he shall continue in office for the remainder of his unexpired term, subject to the recall as before. If a majority of the votes cast at such an election be for the recall of the officer named on the ballot, he shall, regardless of any technical defects in the recall, be deemed removed from office, and the vacancy shall be filled by the city council as in other vacancies. So if it fails, it stays on, or if it goes forward, it's removed. Section 111, limitations on recall. No recall petition shall be filed against the mayor or councilman within 6 months after he takes office, nor in respect to an officer subjected to a recall election, and not removed thereby until at least 6 months after such election. That makes a lot of sense, because, like I said, a witch hunt can come up, and it's, you're 1 month into it, and you just, I think that was good. I was good with that. Okay, section 112, district judge may order election. Should the city council fail or refuse to order any of the elections as provided for in this article, when all the requirements of such elections have been compiled with by the petitioning qualified voters in conformity with the article of this charter, then it shall be the duty of the district judge, upon proper application being made thereof, to order such elections and to enforce the carrying into effect of the provisions of this article of the charter. Is that still law.
So that's if the city council says, nope, no recall election, even though everything was proper. One of the petitioners can go to the district judge and say, we approve the election. That works.
Question? It's okay with that? Okay, according to our agenda, we were only to discuss an appropriate action on the review of Articles 9 and 10. Okay, we're okay with what we have discussed, and we've directed the attorney to review and report next meeting what we talked about today. Okay, now I'm going to go to item number 5, discussion appropriate action to review Articles 1 through 8. This is something that we decided we wanted to do after we reviewed the articles. Go back if we have any other questions of something that we have reviewed from Articles 1 through 8.
We inserted this agenda item on all of them just so that we could go back and talk about things legally.
If someone wasn't comfortable with something.
If somebody had an additional thought, you know, you're driving along and something comes to you and you wish you had thought of it before, that's sort of why this is here, so.
No, I think we kind of caught up last time. I'm good.
And in this memo, which I just gave you, I thought it was emailed to you, and I apologize for that. This is just summing up what we've done before. So in the next several days, next week or so, I'll send a memo where we talk about what we talked about today and sort of give my thoughts. And I'll give you a chance to review this until we meet next time, so we can incorporate any feedback. We just want to make sure that we're getting what everybody said right. So,
As we go along.
as we go along, so that we're not sitting here next month and it's like, well, you know, I thought we said this, so.
Okay, a quick question, since this is a public meeting, and should somebody decide, want to know, since, okay, I want to know what they've been talking about. Can this be requested by anybody?
It can now, since it was distributed in this meeting.
Okay.
And it was drafted knowing that, you know, when you're an attorney, you put every confidential attorney-client on everything you do, just sort of, so that's why it says that, but, and I won't share it with anybody, but you're at liberty to.
So if somebody were to come and we give an extra copy to the city clerk or the city manager, and somebody says, well, I know that there's city charter committee's been meeting and all this, I just want
Well,
to
it's
see.
just like that article, that letter to the editor.
I don't have a problem with anybody asking to look at it, I mean.
And all of this, everything that's here has been said in a public forum, which
Sure.
is this meeting already, so, I'm comfortable with it.
I am too. I mean, like I said, we're all about transparency, and we're doing this to be able to bring our charter up to date.
How will this be, I guess, something similar to this will be given to city council, as this is the recommendation?
Right, so this was several meetings worth of recaps, and I sort of decided to start doing it after every meeting from here on out, we should have a memo like this. And then at the very last meeting, we're gonna have, this is sort of what I'm envisioning, this is sort of what we're gonna present to council article by article. So here it's section by section. These are the sections you asked to have amended. These are sort of why the footnotes say, sort of what the discussion was and why we did it that way. The very last memo, sort of in my mind, is, okay, Article 1 will say all of these things. Cleaned up language, new provisions, rearranged provisions. So the last memo will be that big one, where we sit down and go through it. But you'll have it a few days before the meeting.
But at what point does this get mailed out to all the registered voters in the city police?
So it's after the council approves it. So,
But we gotta also remember that we made these recommendations. Council can come back and strike, you know, and then
right.
you have to go back and redo it, and then that's the final draft that gets sent out to the public. And
And one of the reasons I put footnotes here is to explain why certain things were done a certain way. And sort of sometimes there's some discussion about what the discussion was here. Because if I was a council member, sometimes I look at something and say, well, why did I do that? I want them to be able to look at it and say, oh,
Sure.
there was some discussion about this. This is what the commission, you know, decided.
Is the normal practice to do everything and then present it to council? Or can you present sections, that way they won't be
piecemeal.
bombarded. But
Yeah, so I have seen it both ways in different kinds of cities, so it just kind of depends on a shot clock here because the November election
Right around the corner.
is right around the corner.
I would think, if I was in council, I would appreciate giving me pieces at a time instead of throwing everything at me and here and now review all this.
But then from one month to another, a lot of stuff happens and you kind of forget what you talked about last time and you have to kind of review it anyway, so.
And then, like I said, the next, I think we have 2 more meetings, one in July and one in August. And, you know, what if we come back and we're in the discussion of appropriate action to review Article 9 through 13, our last meeting, says, you know what, to have change of heart, you know, I want to go back to Article 2.
Well, maybe not to take action on, but to review.
Or maybe just,
You know what I mean? So that
because
we-
it's
If we
this
make
is-
changes, we make changes or whatever.
Yeah, it's, you know, this is public record. I mean, they should have, they should all be getting a copy of it anyways.
I don't think at the end that the new charter will be so much
Yeah.
that they would be able to kind of go through it. They're gonna see the notes, they'll ask questions for any clarification, and then,
At any point in time, I mean, they have questions as we're going along. I mean, they can call all of us to a meeting to ask for,
Yeah.
you know, hey, what were you thinking about this one, you know?
I think our council right now is very conscientious.
Mhm.
Oh,
So
yes.
once we give them the draft, I think they'll take a really good look at it and have all their questions all at once, rather than a little bit at a time.
And it could be that would be the only item on the agenda when they,
Review it.
Yeah.
other than accounts payable, minutes, approving minutes and stuff like that.
Well, that's
Can
good.
then the special meeting?
That's like my next question. Once that, the presentation that's being done for city council, does it have to be in the, I'm thinking it should be, but does it have to be in a regular meeting or does it have to be in form of a special meeting when they're going to approve for this to go to the voters?
I actually don't know the answer to that question.
That's a good question.
Yeah, it is a good question.
Because there'll be more to it, because if they just accept it, then they're gonna wanna go ahead and call the election.
Right then, right there.
Well, let's,
To get the ball
let's find
rolling.
out and,
Yeah.
and that way we know what we're coming up against. But again, you know, if, I don't have a problem if the council got a copy of this or anybody in the public got anything, you know, and this is something that we're proposing and.
So, once the council does decide, okay, this is gonna be what we present to the public, how will it be presented so they can see this is what the charter says currently, this is what we wanted to say, or they're just gonna have to compare 2 documents? Will it be,
Will it
It's a
be
discussion we
previous-
probably need to have. It's a discussion we need to have. That was the best way to present it.
so that they can, because something might look good if you just present it like that, but I think you want the context of what it did previously say.
Absolutely, yeah. No, I agree with you.
What changes are being.
And I've been thinking about that a little bit, about what's the best way to present it to folks and.
Because it's a lot, it's the
Right.
whole charter rather than if we were just doing 1 or 2 issues.
That's one of the reasons that I'd like to do sort of article by article, because you could do 150 ballot propositions, section 1, section 2, and that's just, not seeing that, you know, that's messy.
You're gonna get people that,
No.
that say, I don't want any
I-
part of this.
I don't want any part of this, no to all of them. Vote no to all 165.
Yeah, because I mean, you know, actually the people that are going to be looking, the public that looks at it, they're gonna go to, okay, here's the red part, they struck that. They might not even go into the rest of the stuff that's there. They wanna see what the changes are, you know? And then maybe later on come back and read it, but, I mean, because if it's in red like this, that draws your attention to it. Okay, so they struck that out, okay,
What did they,
right.
see, but when you see, oh, they struck out all of this and they simplified it to only registered voters of the city shall be eligible to, that, like, boom, that makes sense.
Yeah.
Because I mean.
And you see what it was compared to, and you can say, yes, I want it simplified to 1 sentence that,
What we should do is, before we discuss this anymore, is just put an agenda item for the next agenda about process for presentation of
Okay.
charters.
That'll work.
Yeah, I kind of,
You think
sorry
it's
about
a
that.
separate-
No.
you
Yeah, I
think
think that
it's
it's,
one?
yeah, we should, it should be on the
I
agenda.
like the way that it's presented like this, because that does help.
And if you could provide maybe some examples of how they presented before. others
Absolutely,
maybe?
yeah. And I think that, I'm going through here, that maybe our August 1st, what is the last meeting that we have scheduled, that
August
we
1st.
discussed 13? Is that,
August 1st.
that's, yeah, August 1st. We can sit down and discuss sort of the best way to roll it out. And maybe spend the July 25th meeting finalizing substantively and sort of what we want it to look like.
July 21st, we've got 11 and 12, Article 11 and 12. We're going to be going over, and then August 1 is the 13th, Article 13.
Should we just finish up those last three altogether, and that way we can have
And that's-
that last meeting to really look at it?
Because it's only one article that we're looking at.
And that gives him,
And then, of course,
that gives him that week's time to put it all together rather than everything except one chunk.
and we're reading over it, and if we have questions on it, that's where we're coming up with the questions on that. So,
So, do we need a motion to do that?
So I'm gonna, discussion of articles, next time is Article 11 through 13. I'm gonna do a separate item for discussion of Article 10 again, because we're basically, you've asked for like a lot of revisions of 10, so I wanna do a separate discussion on that. And then we can do discussion to review Articles 1 through 9, just sort of the catch-all, and then we can do discussion of process for charter rollout to council and citizens or something. So we can discuss this more comprehensively.
for discussion, we've already got caught up to section 1 through 8, Article 1 through 8.
I think it's 11, 12, and 13, that's the two are to do all those.
So it's on the 25th, is the next one, I'll see you.
25th.
And we want to do it at 6 p.m. again?
Sure.
Same time, same place?
Do we have any other questions regarding to number 5, discussion appropriate action to review Articles 1 through 8? We're good with that. Number 6, and a motion for adjournment.
So moved.
Okay. We have a motion by Ms. Ramirez, a second by McDaniel. All those in favor? Aye. Motion carries. Those who want to stay can.
That's all, folks.